to this, the second session in the three-part series that Cornerstone is putting on in Court of Protection Masterclass series. Today, just to make sure that you're at the right webinar, we are looking at navigating closed material and closed hearings, and India will be addressing you on that. We are also looking at contempt proceedings in the Court of Protection. You'll be hearing from Lee on that. And then lastly, myself, I'll be talking about the inherent jurisdiction in relation to vulnerable adults right at the end, and multitasking by chairing and dealing with the questions that I do invite you to put into the chat function at the bottom. Just briefly to introduce my two colleagues, starting with Lee. He probably doesn't actually need an introduction. He's extremely well known in the area of court of protection, has a very solid and experienced practice there. He's also well ranked first in the Chambers and Partners in the Community Care, and he rounds off his extraordinarily busy bar practice by preparing part-time as a deputy district judge, as well as a nominated judge in the Court of Protection. Also with us, as mentioned earlier, we have India. India, I am very convinced, is biting on the heels of Lee. She has been ranked as a rising star, yes you are, in the Legal 500. She has a very solid court of protection that she's built up since she's been with us at Cornerstone Barristers, but she also practices in the area of community care, housing and licensing. So without any further ado, I think we'll start with you, India, please.
Thanks, Peggy, and thanks for the introduction. Good afternoon, all. As Peggy said, I will be discussing closed material, specifically closed hearings and closed material. Next slide, please, Peggy. And thank you. And next slide. Thank you. Just to start off with the starting point in CoP proceedings, as I'm sure everyone is familiar, the starting point is that all parties and P, if P is not a party, should fully participate in proceedings. What does that mean? Well, of course, every party and P should have access to all documents that have been filed and served, attend all hearings, but also attend all roundtable meetings. And the reasons for that full participation is, of course, to ensure that open justice, which of course is fundamental to the dispensation of justice in a modern democratic society, to enable parties not only to fully present their case, but also to allow the court to have all the assistance of all parties in order to come to the right decision for P. And another fundamental reason is, of course, that if a court makes a decision based on any materials which are adverse to a party, Article 6 and also common law fairness dictates that that party should have the opportunity to consider and respond to any adverse material. Next slide, please, Peggy. So what is closed hearings and closed material? Closed hearings are those hearings which exclude a party and their representatives, if that party is represented, from attending a hearing. And a closed hearing is normally made on an application from a different party by the court. This is, of course, different to a private hearing, where that hearing is where all parties to the proceedings attend, but members of the public or members of the press are excluded, and there'll be a reporting, normally, of course, a reporting restriction order in place. Closed material is material where the court has ruled by court order that specific documents should not be disclosed to a particular party. All of the principles, or the majority of the principles I will be discussing, comes from the guidance, which of course I'm sure is very well known, but the closed hearing and closed material guidance, and the reference is on this slide. Next slide, please. This slide just sets out some examples of when the court may depart from the starting point that I outlined earlier. Most likely this will be when a closed hearing and or closed material is required to secure P's rights under the European Convention of Human Rights, or in arguably more unusual cases, if a closed hearing or closed material is required to secure another party's own interests, or to secure wider public interest. In relation to the former, to secure parties' own interests, this is arguably more difficult to justify than the latter. When the court departs from the starting point, given the Article 6 issues, the court must ensure that not only any restrictions in terms of closed material, for example, are as limited as possible, but also that any orders dictating that disclosure is to be withheld from a party or parties are only maintained for as long as strictly necessary, and therefore the court must keep that order under regular review. Next slide, please. So just to delve a little bit deeper into closed hearings, if making an application for closed material, when making that application, you should consider at that stage if you need to make an application for a closed hearing as well. And often you will very likely need, depending on the circumstance of the case, of course, very likely need to make an application both for closed material and a closed hearing. The considerations that the court will apply when considering an application for a closed hearing is firstly, of course, that this is a matter of last resort. The applicant has a burden to demonstrate that all least restrictive or less restrictive methods have been explored, for example, reductions of material, and the courts operate from a starting point, which is what is necessary to protect and promote P's best interest, but also the court must balance, as I go into talk later on, about the ECHR rights of the other parties. When making an application for a closed hearing, it is very important that the applicant clearly sets out the basis on why a closed hearing is sought. As I've just outlined, what less restrictive steps have been considered. For example, has consideration been given to redacted material? The application should set out why that has been discounted, why it's been insufficient to meet P's best interests, and why a closed hearing is therefore required. Steps should also be taken to minimise the interference with the other party's ECHR rights, and that should also be clearly set out. If the party that the applicant is seeking to exclude is a litigant in person, the application should also address any contingency plans, for example, in the event that the litigant in person learns of the facts of the application. When the application is made on short notice or without notice, as I'll go on in the next slide, there is another burden on the applicant to explain and demonstrate why it was not reasonably possible to provide the court with full notice. Next slide, please. Thank you. When an application for a closed hearing has been made, there are various procedural matters that need to be considered. There is generally an expectation that a closed hearing will be conducted before a Tier 3 judge. Therefore, it is always important to remember this when making case management and first directions hearings. For example, if it is anticipated, and of course caution must be given for obvious reasons, if you anticipate an application for a closed hearing is required, you should consider this at an early stage when discussing any issues about allocation and when discussing the broader issues of the case and considering the complexity. The listing, of course, must not defeat the purpose of a closed hearing. All parties, and particularly, of course, the applicant, must consider, can the fact of the hearing be disclosed? And if not, the listing must ensure, and this is of course a matter for the court, but the listing must ensure that there's no case identifying information. And again, it's very useful for the applicant and all parties to remember this when drafting orders, because of course caution will need to be exercised so as not to link the closed hearing with any exact open proceedings. In terms of transparency, well, as I'm sure is clear, closed hearings fall outside of the transparency order provisions, and the principles of open justice normally dictate that a reasoned judgment should be provided at the earliest possible opportunity. There are situations where a party or their representatives should not be told of the fact or outcome of a without notice application. Similar to short notice applications, there is of course onerous, and rightly so, onerous obligations on the applicant seeking a without notice application. If a without notice app has been made pre-issue, the court will need to consider who will need to be joined and what information can be provided to those future parties. If a court decides that that a person should be joined as a party, they should then be treated as if they were already a party for the purposes of considering Article 6 and other relevant considerations. Next slide, please. So as set out in terms of closed material, if making an application for closed material at the application stage, again, consider if an application for a closed hearing is also required. When considering closed material, the courts will, as per the guidance, consider a staged approach. The first stage arguably is, would the disclosure of the material involve a real possibility of significant, and I emphasize that, significant harm to P? If yes, second stage is, would P's overall interest benefit from non-disclosure? In order to answer that question, the court will need to weigh P's interest in having the material properly tested against the magnitude of the risk that the significant harm will occur and the gravity of that harm if it did occur. Again, if the answer is yes, and the court considers that P's overall interest would benefit from non-disclosure, the third stage is to consider the balance between P's interest in terms of the circumstances of the case against the other party's Article 6 interference, as well as the relevance of the material to the central issues in the case. Overall test for the court and the applicant to demonstrate for closed material is arguably, is it strictly necessary to meet the risk? And also, I would also add to this that any interference must of course be lawful, necessary and proportionate. Therefore, to assist the court and to give you the best possible chance of succeeding in any application, the applications, I would suggest, need to clearly set out each stage, the basis for each stage, and of course exhibit supporting evidence to justify why each stage is met. And again, one of the key principles of these stages, I would also assert, would be that you need to ensure that the evidence clearly demonstrates why the material would cause significant harm. So far as possible, and sometimes depending on the circumstance of the case, it may be difficult to avoid advancing speculative arguments, because of course you'll be talking about the future in terms of the significant harm that could be caused. But that is why it is very important to set out clear reasons and clear evidence to justify the application. Next slide, please. When considering an application for closed material for some other compelling reason, the courts will apply the same staged approach, but with the additions of the highlighted parts in this slide. So in terms of stage 3 of the balancing exercise, the courts will consider these additional factors, namely the nature of the interest to be relied on, the interest of that party in question, and the impact of non-disclosure on the court's ability to discharge, of course, its central obligations in relation to P. Next slide, please. During any ongoing proceedings, the courts and the parties need to be aware of the ongoing principles from the guidance. Whenever a decision has been taken, for example, for a closed hearing, the courts should be recording in a judgment and provide a judgment the reasons to enable disclosure at an appropriate point in the future. And of course, if an appeal is brought, to enable the speedy and proportionate determination of any appeal. When considering a closed hearing, the court should again consider a judgment, and the parties should be asking questions. For example, is a short open judgment possible whilst there are ongoing proceedings? E.g., for example, is there a possibility of having a short open judgment about the fact of a closed hearing? If a short judgment can be provided, parties should invite the court, so far as appropriate, to ask clear reasons to be recorded in the judgment. For example, what are the answers to be given to any questions raised by an excluded party in future open hearings? And again, similarly, what answers will be given to any non-parties, for example, the press or the public, if they attend future open hearings? So it's again ensuring the balance between ongoing open proceedings, but you have closed hearings within those proceedings. There needs to be very clear difference between silence and, of course, active deception, which I'm sure I don't need to say, but needs to actively be avoided for the clear reasons that it would undermine the confidence of parties and the public in the judicial system, and of course is clearly incompatible with the relevant parties' ECHR rights. Again, as I've already set out, it is very important that any restrictions, either in terms of closed hearings or closed material, are kept under active review. The court and the party should be inviting the court to always consider if the disclosure of the fact of the hearing or the closed material can be disclosed, and how best to manage the consequences of any ongoing disclosure. In terms of the closed material, just to raise, if there are any advocates meetings held between the included parties, i.e. those parties who have access to the closed material, those minutes should ideally be minuted and include specific consideration of the issues. At the end of any proceedings which have involved, for example, closed material, the court should arguably be giving an open judgment at the conclusion. In exceptional circumstances, there may be appropriate cases where a closed judgment will need to be accompanied by an open judgment. However, that is, of course, an exceptional course to be taken, as it would mean there'd be no public record of why the court ultimately reached its conclusions. Next slide, please. Next slide, please, Peggy. Thank you.
Sorry, India, it's not moving.
Sorry.
I'm seeing what I can do. Yeah.
Thanks, Peggy. Thanks very much. This slide, in the interest of time, I'm not going to go through these cases, but this slide is just here to hopefully assist and highlight some of the most helpful and important cases in the areas of closed material and closed hearings. Just to highlight very briefly, the second bubble P application to withhold closed material 2024 is a very recent authority from this year, where the court considered the guidance and considered in that case an application to withhold a CoP 9 and skeleton argument. And in that case, the court granted the application application, but emphasise principles from the guidance, which I have already outlined, but just in very brief summary, included that any interference of closed material with the rights of any other party must be lawful, necessary and proportionate. The disclosure, the withholding of disclosure must be kept under review, and the court should consider what is the shortest period to withhold that disclosure and when it's proportionate to allow the other party to receive that disclosure. I'm now going to pass over to Lee, who's going to discuss contempt. Thank you.
Thanks very much, India. Yes, so I'm going to talk about contempt proceedings within the Court of Protection. I'm going to talk through the process of a contempt application and a hearing for contempt and the possible sanctions that the court can impose if it finds somebody to have been in contempt. But I'm also going to talk and hopefully emphasise that it's not just a case of looking at contempt applications and when something goes wrong and something's been done which we think shouldn't have happened, right, let's look at our notes on contempt proceedings and crack on with a contempt application. I'm going to try and emphasise that there's some essential building blocks for a contempt application, which you have to think about long before there is a contempt, long before there's a breach, because if those building blocks aren't there, you can't proceed with a contempt application. So I'll look at what those essential building blocks are. The short point is that not all breaches of court orders justify or permit an application for contempt, and that's probably, if you think about it, quite good news, because otherwise every time someone's late with a witness statement, or if I'm late submitting a position statement, or late submitting the draft order when the judge has asked me to get it in by 4 o'clock on a Friday and I haven't heard from the other parties, that's technically a breach of an order, but thankfully those orders and directions, breach of them doesn't give rise to a contempt. So we need to look at if an order is something that we think has to be enforced with the potential powers of contempt proceedings, we have to look at the status of that and the procedural steps that need to be taken to make an order something that's capable of being enforced by contempt proceedings. But we'll come back to that as we go through. So Peggy, can we have the next slide, please? Thank you. So this is all governed by Part 21, which is fairly short but very detailed, and it's absolutely worth looking at Part 21 if you have to make a contempt application. The application is made under Part 10, an application within proceedings, but the meat of the requirements is set out in Part 21. And the next slide, please, Peggy. Thank you. There's an issue potentially with contempt applications that you may need permission to bring them. Permission is required if it's alleged that there has been an interference with the due administration of justice, or that a person has knowingly made a false statement verified by a statement of truth. But the breaches that are more commonly, or the contempts that are more commonly dealt with, and certainly that I've come across more often, tend to be allegations that somebody has breached an order or breached an undertaking, and you don't need permission to bring contempt applications in those scenarios. So if the court's made an order that somebody can't CP or can only CP on certain dates and that's being breached, you don't need permission to bring that application. I've said permission would be required for an allegation that there's been an interference with the due administration of justice. You might ask, what would that look like? Well, I'll give you an example at the end of a case where a party to proceedings fabricated an order for disclosure and sent that to a hospital to try and get medical records, and that was held to be interference with the due administration of justice. So that gives you a flavour or an idea of what might fall into that category. But as I say, ordinarily, most frequently, we'll be dealing with alleged breaches of orders for which you don't need permission to bring your application. And the next slide, please, Peggy. We're here talking about one of those essential building blocks that I mentioned a moment ago to make a contempt application. There has to be an order of the court that's carries with it a penal notice, and I've given there the definition of a penal notice, which is essentially an assertion to the parties that this particular order is very serious and breach of it could be punished by contempt. So there needs to be an order in clear terms with a penal notice, or there needs to be an undertaking given by an individual. So breach of an order with a penal notice or breach of an undertaking can result in proceedings for contempt. I've put there undertaking, I've put form N117 question mark. Form N117 is the form that's used in the county courts and in the civil courts to record an undertaking. There isn't, to my knowledge, a similar form within the Court of Protection forms. But the benefit of that form is it sets out a form of wording a bit like the penal notice, a warning to the individual that an undertaking is a very serious thing and a breach of the undertaking can be punished by contempt. And so if somebody is offering an undertaking to the Court of Protection, I would suggest asking the court to use the form N117, if necessary, crossing out, well, will be necessary to cross out county court and write Court of Protection in, or at least, if you're not using the form, have very clear recitals in the order that the court explained to the individual what an undertaking is and how breach of it can result in proceedings for contempt. The point here is that we're trying to establish that an individual knew that what they had promised or what they were told they weren't allowed to do, and that they were given fair notice that if they breached their promise or breached the order, that they could be punished. And so that's really one of these essential building blocks. The next slide, please, Peggy. Actually, sorry, just before I move on to this slide, one of the other essential building blocks is that there is service of the order with a penal notice needs to be personally served on the individual. And I would suggest, if you, clearly with an undertaking, someone's at court and given the undertaking, but you might get an order that prohibits a third party doing something, or sorry, a party doing something, and you get a penal notice attached to that. You will, if you want to be able to bring contempt proceedings, you'll have to be able to personally serve that order on the individual. So, and you should arrange personal service, and you should have evidence that you've undertaken personal service of the order. But I'd urge you to think about problems with service immediately when you're getting the order. If, for example, the person you're getting the order against is generally not engaged with proceedings, might have returned all the posts that you sent to them, but they turn up to the hearing at which the court makes the order, you might ask the court to dispense with personal service in that case, because you know this individual is very unhappy with the order that's been made, and they'll return the post, or they'll not answer the door, or whatever. So it might be that you'd ask the court to dispense with personal service in that sort of situation. If you don't get good personal service of the order, or the court hasn't dispensed with the requirement for personal service, you're not going to be able to proceed with proceedings for contempt. So it's important to think about whether you can achieve good service, and if not, ask the court to sanction a different form of service at the outset rather than wait for the breach to happen. The next slide, please, Peggy. So moving on then to the requirements for the application, these are all set out in Rule 21.4, and there's a long list of things that need to be addressed, and I'd suggest looking at that very closely if you are making an application. The first point to note is that the evidence that's required here is affidavit evidence, which needs to be sworn, not witness statements. And the things that need to be covered within the application and the evidence are the details of the alleged contempt, precisely what's alleged, on what date, who did what, and how is that said to be a breach of the order or a breach of the undertaking. The evidence has to include confirmation that there was a penal notice, so that's why it's essential to get a penal notice attached. If you think you might one day want to bring contempt proceedings, you need to have thought about that when you got the order to get a penal notice attached to it. You need to include evidence of personal service or address why the court has dispensed with personal service. And there's a long list of things that need to be included with your application that show the defendant what their rights are, including their rights to remain silent, to be represented, and the availability of legal aid to be represented, and to provide evidence if they wish to, but they're not required to provide evidence, and also information as to the potential punishments that would arise from the contempt, and also informing the defendant that if they were to apologise and admit their contempt, that might reduce the sentence of that they receive. So all of the points in that rule 21.4 have to be met with the application. If there's a deficiency, that might mean that the application can't proceed. So it's really important to look at 21.4 very closely. And this application with all of the supporting evidence needs to be personally served on the defendant. And again, you'll need evidence as to personal service. The next slide, thank you, Peggy. Dealing with this issue of service, so not now dealing with the service of the contempt application, but service of your original order with the penal notice attached to it. As I mentioned, the general rule is that you're going to have to personally serve that order. If there's going to be a potential difficulty with serving that order personally, I would suggest addressing that as soon as possible. Don't wait for a breach to happen and then worry about, oh, we can't proceed with contempt because we haven't achieved personal service. It is possible for the court to dispense with personal service retrospectively, and I've given you there in the slide an authority for that, and that's an application which I've not in that case, but I've made a similar application in a case since in the inherent jurisdiction, which succeeded, but it succeeded because the defendant had been at the hearing where the order was made, and it was only an inadvertent oversight by the solicitor to not personally serve it after the hearing, but it was served by email and the defendant had corresponded with the court about the order. So there was absolutely no doubt that he knew that the order had been made and that there was a penal notice attached to it. There just wasn't personal service. But in that circumstance, we were able to dispense retrospectively with the requirement of personal service and proceed with the contempt application. But it's a hassle you want to try and avoid. So if you're concerned about achieving personal service, deal with it at the outset, not when you've had a breach and you're trying to make your application. Next slide, thanks, Peggy. So you've got your building blocks, you've had an undertaking with the requisite warning given, or you've got the penal notice attached to an order, you've had personal service of it, and there's been a breach and you've been able to gather evidence of the breach and put together your application, hitting everything in Rule 21.4, and you've personally served it. You're now going to a hearing. The Rules 21.8 set out the process for a hearing and the requirements of a hearing. Almost always hearings will be in public. It's possible for there to be a private hearing, but for much the same sort of principles as India was talking about open justice. That's difficult and unusual for contempt proceedings, particularly when you bear in mind that in contempt proceedings you're potentially taking someone's liberty away from them. So it's important that that be public, and only in exceptional cases will that be heard in private. Because of the serious nature of the proceedings, judges and advocates will need to be robed for these hearings, whether they're public or not. And in any case where the court finds somebody to be in contempt and imposes a sentence of imprisonment, the court will always make a judgment published recording its reasons, either a written judgment or a transcribed judgment. So there will always be a public record of any committal order that's made sending somebody to prison. Thanks, Peggy. Now just looking at what the roles are of the applicant and the defendant within a contempt application. These are some basic points, but the applicant has the burden to prove that the alleged breaches have happened, and you'll have the burden on everything else to prove service and to prove that there was a penal notice. That's all on the applicant. The standard of proof, because somebody's liberty is at stake, is the criminal standard beyond reasonable doubt. So it's all on the applicant, nothing on the defendant. The defendant doesn't have to disprove anything. They can remain silent. They can test evidence by cross-examining the applicant's witnesses, but they don't have to give evidence themselves. They can give evidence, and often the court will set directions inviting the defendant to give evidence. And there's specific provisions which I've set out in the practice direction about any statements the defendant gives. Unless the defendant then actually deploys them at the hearing, you can't rely on those statements as amounting to admissions or evidence against the defendant. So essentially, it's all on the applicant to do the running and to make out the case rather than on the defendant. And the defendant can engage or can simply just test the evidence which has been put forward. And at the end of your hearing, which you've had in public ordinarily, you'll get a judgment with findings of fact about whether there's been breaches. And then if there has been contempt, you then move to the question of punishment, which is the next slide I'll come to, Peggy. Thank you. So punishing contempts that have been found, the maximum prison sentence is 2 years or a fine of £2,500. There's some guidance given in a relatively recent case of Macpherson and Sunderland, and that was a Court of Protection case. And if the court does impose a sentence of imprisonment, it can be suspended or suspended on terms. Usually on terms means suspended on the condition that the person continues to comply with the order. But as you'll see in the list of cases I'm about to turn to, and Macpherson's one of them, that doesn't always achieve the desired effect. So Peggy, if we can go to what I think might be the final slide, some examples of contempt proceedings. So you'll remember I said at the outset, an example of interfering with the administration of justice would be fabricating an order. Well, that's what happened in the Dahlia Griffiths case, which was a case that I had some involvement in at the outset when it was before Judge Hilda. And what happened in that case was that the Dahlia Griffiths was a relative of P and had applied for orders for disclosure of P's medical records to her, and the judge had refused that, but had made disclosure orders in favour of the official solicitor as a standard. But Ms. Griffiths decided to fabricate an order purporting to be an order from Judge Hilda and served that on a hospital to get medical records disclosed, and that resulted in a 12-month prison sentence. The Liverpool Victoria case isn't a CoP case, but it's a case about false statements of truth, false witness statements, and there the guidance from the Court of Appeal was 9 to 12 months for that sort of contempt. That was a case about a doctor producing reports to support whiplash claims who had produced a false report verified with a statement of truth. And Sunderland and Macpherson is, this was the third case I've given you there. The second one went to the Court of Appeal, which I talked about in the last slide, which gives general guidance. But what happened in Macpherson was that the Macpherson had breached transparency order by publishing videos and articles online about P and referring to proceedings. She was given a 28-day prison sentence, suspended for a year. She appealed that and didn't succeed. She then carried on making social media posts identifying P even while she was on her suspended sentence from the first breach, and that resulted in the court imposing an immediate sentence of 3 months on her, plus activating the first 28 days, so she got 4 months prison sentence for those breaches of the transparency order. So that gives you a flavour of the sort of punishments which might be meted out to people who have breached and been found to be in contempt. So I think that concludes what I was going to say. I'll hand over to Peggy.
Thank you, Lee. Before I start, I just wanted to mention there's one person that's got their hand up. I'm not able to access you directly, but I would invite you to put any comment or query or problem or issue that you may have in the question and answer box, so we can all read it and hopefully address it. And then generally, I want to invite everyone to put any comments and questions that you may have in that question and answer facility that you should be able to find at the bottom of your screen. So yes, talking about the inherent jurisdiction as relates to vulnerable adults, it's a huge topic. I thought the best way of dealing with it was to just look at 3 cases that have been handed down this year, so 3 recent cases, and I hoped to have chosen those cases in relation to practical points or tools that could give you and your clients when you have to contemplate bringing a case in the inherent jurisdiction. But of course, before I can get to those three cases, I need to set the scene slightly, because first it will help you to understand why the interventions have been made, or the particular interventions that were made in those cases had been made. And also because it is confusing, I find, if one jumps straight into recent case law. And so the first slide I have here is a quote from essentially the beginning of the vulnerable person's inherent jurisdiction journey. It's a case of In Re F. It was to deal with a patient who had a mental disorder. The doctors wished to sterilize him. This was a very big intervention in his life, and so they wanted to seek a declaration of lawfulness from the court. And what the House of Lords, as it then was, said was that the common law has a great safety net which lies behind all statute law and is capable of filling gaps. And I bring this quote to you because first, it is a safety net. So when you have very vulnerable people, you can look to the inherent jurisdiction. It lies behind statute law. This is important because we now have the Mental Capacity Act that sits adjacent to the inherent jurisdiction, and it's capable of filling the gaps left by that law. So we have to look at the inherent jurisdiction, the Mental Capacity Act, and then see where the inherent jurisdiction can be used to fill those gaps. Just two more setting the scene cases. The seminal cases you'll all be well aware of Re SA, that's a 2005 case before the Mental Capacity Act that essentially set out the guiding principles that we apply when we apply the inherent jurisdiction. And then the case of DL and A local authority case from 2012, which for our present purposes essentially said that all the principles that were set out in Re SA endure post the coming into effect of the Mental Capacity Act. I've got two quotes from each of those cases, well, one quote from each case, so two quotes in total that I wanted to bring to your attention. The first is this paragraph, which is essentially the nub of what the inherent jurisdiction is. It can be exercised in relation to a vulnerable adult, so you'll need to have evidence that the person before you, I'll call them P, but it's P in the sense of being a vulnerable adult, is vulnerable, who either are not incapacitated by mental disorder or mental illness. So we're looking at adults who are capacitous within the terms of the Mental Capacity Act, but nevertheless may have a lack of capacity in the inherent jurisdiction. And they are or reasonably believed to be under constraint, subject to coercion or undue influence, or for some other reason deprived of their capacity. So for those three reasons or three factors, their ability to make a decision may be so vitiated or overborne that they're not able, or they're considered not to be able to make a capacitous decision. And then the second case, or second quote that I wanted to bring your attention to from DL is that this is a facilitative jurisdiction. So the interventions, the orders, the declarations, the injunctions that you'll be seeking for the court are to facilitate the production of a space, what is sometimes called a safe space, for the individual to regain the decision-making capacity. So it can be called a safe space, it can be called a scaffolding that's placed around, or a framework that's placed around the individual that stops the vitiating factor having an effect on them, such that they're able to regain their capacitous decision-making. Looking at the first case from this year, I wanted to draw your attention to, it's Norfolk County Council in CA, a recent case. I think it was handed down in October, so about a month old. And the reason I focused on it was that it illustrates the concurrent use of the Mental Capacity Act and the inherent jurisdiction in the same case. So this was a case where a mother and her daughter were in a very dysfunctional, abusive, enmeshed type relationship. Daughter was treating her mother very poorly indeed. The local authority stepped in. The court made capacity decisions, found that she lacked capacity to make decisions about her care and conducting proceedings and property and affairs, but that the lady had capacity to make decisions in relation to a lasting power of attorney for health and welfare that her daughter had held, as well as contact with the daughter. The problem here was that there was abuse promulgated on the mother by the daughter. There was a fact-finding hearing. A sample of 11 allegations of abuse were found proven, and so what to do? In that particular case, the judge found that the pattern of abuse was such that the mother was subject to undue influence by the daughter, and also that she was a vulnerable person by reason of her age and ill health. And so that opened the pathway for the judge to be able to make interventions under the inherent jurisdiction where they were really needed, because mum had capacity to make decisions in relation to contact with daughter, and essentially was unable to not make decisions that were, one would say, were in her best interest. She wanted to continue contact with her daughter, even though her daughter, on an objective view, was abusing her. So one was looking to the inherent jurisdiction to help to solve that problem. But before we go to the specific interventions in that case, I've just put this particular slide on because I wanted to highlight or bring out the staged process that the court goes through before you can get to the end, before you can get to the interventions and the orders that you sought, because it illustrates what evidence you will need to put before the court. So the first is that you will need evidence to answer the question of whether P was in fact or is in fact a vulnerable adult and is in fact, as a result of that, in need of protection. The second is that you will have to satisfy the court that there's no other statutory scheme that can be used to protect P from the contact risks posed by her family. And this harks back to the Re-F case that I mentioned earlier, that the inherent jurisdiction fills the gaps, that plugs the holes left by statute. So if there is any other statute that is applicable for example, in relation to domestic violence, then one ought to use that first before one has recourse to the inherent jurisdiction. And then the third, and very important, is whether the proposed intervention, so the orders or the injunction that is being sought, are necessary and proportionate in Article 5 and Article 8 of the ECHR terms. So you will need evidence on that as well. The particular interventions in this case were threefold. So first, they had supervised contact between mother and her daughter by way of the carers. So they had 24 care put in place. They also had a series of injunctions that injuncted the daughter to essentially behave herself and act in an appropriate way to her mother. And then they also directed the parties, this is in column 2, to jointly instruct a psychologist to consider the family relations and how they can be managed so that the mother could remain safe when she sees her family, and then it may be possible for unsupervised contact to take place. So you can see in those three interventions the construction of the safe space, so that was the supervised contact and the injunctions, and then the facilitative aspect of it, which was to get a psychologist in to try and help the family to behave in a more functional and less abusive manner. Moving on to the second case, this is ALAMP. Again from this year, I think July of this year. This was a very sad case indeed. P was a vulnerable adult. She was about 27 years old. She'd been under the influence and coercive control of her father for essentially her whole life, and it was a very high level of control. He controlled how much she ate. He controlled how much money she had. He controlled access to her menstrual products. He controlled where she lived. At one stage, they were living in a car on the driveway of the property from which they had been evicted. So every aspect of her life had been controlled by her father for her whole life. Local authority were obviously concerned about this. They obtained a series of orders, one of which was that they removed P from her father, from living in the car, placed her in an appropriate placement, and put in place other therapeutic and therapy type support. Judge recognized that this removal of an individual, and at that stage there was a deprivation of liberty, this removal of an individual from living with her father was a very draconian nature of the order. But the reason I wanted to bring this particular case to your attention is that it shows the boundaries of what the local authority can do. It mentioned earlier that these orders have to be protective and facilitative, but what happens when they cease to be facilitative? How long do we go on for? And the answer is essentially in this case, and what it says is that the intervention, so the order in this instance, taking her away from her father, has to remain necessary and proportionate. So in the first instance, it was necessary and proportionate, but now as time has moved on and things have changed, does it remain necessary and proportionate? So I see there that I say the limit of legal intervention to protect a vulnerable adult who can't or won't take advantage of the opportunity given to her to extricate herself from a relationship of control and dependence. So she was put in a safe place, but she was either unable or unwilling to take advantage of that and extract herself from the enmeshed relationship that she had with her father. So there we have the quote from the case: the inherent jurisdiction is not unboundaried, and essentially, if the intervention sought are no longer doing anything, then it's no longer necessary, proportionate, and will be an unjustifiable interference with P's rights. Oh, the other thing that was interesting from this case was right at the beginning, they used what's called a Harbin and Masterman inquiry. So this is where the official solicitor is directed to make inquiries about essentially anything, such matters as the court thinks fit. In this particular case, it was an instruction to an independent social worker to consider P's circumstances, to see whether P was in fact a vulnerable adult subject to coercion or undue influence, and thus whether the inherent jurisdiction was the appropriate course to take. So I highlight this because it is a useful tool for local authorities who perhaps in these cases may not have had a lot of engagement from the individual or any interventions with them previously because of the type of life they had lived. So she had lived very apart from, I don't know, society as we know it. And so the local authority did not have a lot of information on her. And this inquiry was one way in which the local authority, or the court rather, was able to obtain information as to whether the inherent jurisdiction was appropriate to use. And then the very last case I draw your attention to is London Borough Hackney in A. This I thought was important because it just illustrates the types of orders that one can obtain in the inherent jurisdiction, in this case against third parties where P has gone missing or has been abducted. So in this particular case, P had been removed from his parents' care, placed in appropriate placement, parent had gone and abducted him, taken away from placement, and the local authority did not know where he was. And so they wanted to essentially get him back. So they sought a collection order, and they also sought an order against the telephone company to disclose information that would lead to the whereabouts of the young man. The judge in that case applied an earlier case from 2010 of HM and PM, which essentially, although it was a children's case, a family case, in a children's case in the family court, also applies to vulnerable adults in the inherent jurisdiction. And that said, the court has the power under the inherent jurisdiction where a vulnerable adult is missing to order third parties to provide information. And the range of orders that can be made, or people against whom the orders can be made, is extremely wide. I've set out there some examples: telephone and IT providers, banks, other types of financial institutions, airlines, travel services. They can also be made against family and friends. So you can ask family and friends to come into court and essentially give evidence on anything they know as to where P may be. These types of orders, just to let you know, are made generally ex parte because the point of them would be negated if the abductor, or the potential abductor, knew about them. So they typically forbid the third party from informing the abductor. And then most importantly, they can direct the tip staff to actually locate the individual, go and collect the individual, or enter private residential property using force with a view to searching that property and taking into custody anything that might help locate the vulnerable person. So very serious interventions indeed that can be used in complex cases where the local authority no longer knows where P is. I think that is my last slide. It's time for the question and answer section of this talk. We've got a nice, easy question. Will the slides be shared, please? Thank you. Yes, they certainly will. We've got email addresses of everyone that signed on to this or filled the form, and they will be sent out, as well as a recording, I think, is placed online as well. So you will have that. I'll read out this question. Lee, I think you might be best placed to address it. It says, just to mention that we act for a defendant in a contempt matter in the CoP, and they have the benefit of legal aid, but it is criminal legal aid and not civil. I don't think we could have acted if we didn't hold a crime legal aid contract with the LAA legal agency.
Yeah, I know that's sometimes an issue. People will, when trying to get representation for defendants, it's not usually the sort of necessarily the solicitors who do court of protection work who will be able to take on the contempt proceedings. So that's a good point. Yes, I understand that it's criminal legal aid, so it will need to be a criminal legal aid solicitor who takes on the defendant's representation. Thank you for flagging that.
I had a question in relation to penal notices, Lee. So you emphasised that one does need a penal notice. What happens, or what have you done if you had your order, it's not been complied with, you've not got a penal notice? Have you then gone to, I don't know, made a CoP 9 application, gone to court?
Yeah, I mean, I'm a bit pessimistic about being able to do anything with if you haven't got a penal notice. I think really the best you can do is to have the order reissued as an injunction with a penal notice and start from scratch. I think you'll run into real problems of fairness. I'm not sure there's any authority which says you can, if you know, retrospectively disapply the requirement for a penal notice. So I think you really need to start from scratch, which is why, you know, I sort of emphasise the think about what you would need for a contempt application long before you have grounds for a contempt. So if you're thinking of an order, you know, might need to be backed up with the possibility of a contempt application, you need to have thought about that at the stage where you get the order to make sure the penal notice is in there.
And just following up from that, have you found that contempt proceedings in the CoP are of utility? So for example, if the individual is on benefits, has their own vulnerability, so may not be imprisoned, is this an effective remedy for us?
Yeah, I think it's fairly infrequent that I've seen CoP contempt proceedings, but they have a place, and where there are, well, the example I gave of the woman who was continually posting social media stuff about P, there was really nowhere to go with that case other than threaten her with contempt proceedings and punish her and send her to prison, because those were quite serious breaches which were not in P's best interests, and there was no other way of winning her round. But I think you're right, in a lot of cases, the person who is sort of breaching the orders probably has their own difficulties, and it might be that there needs to be a more constructive, less adversarial approach for them. And that's another thing that's worth having in mind when you get your orders. You know, is it worth having an order that says that somebody must do this and having a penal notice in it if you think that actually you would never enforce it with contempt proceedings? And there's a more fundamental point there as well, is that you can never really, well, you can never have an injunction against somebody who lacks capacity to understand it. So if somebody who isn't P but is a party to the proceedings but nevertheless has their own difficulties, which might include mental health difficulties, and they just don't understand and therefore won't be able to comply with the order, you probably shouldn't be getting it in the first place. But yeah, it's certainly a problem as to contempt proceedings are fairly blunt, and often there's more complex issues at play, but they're useful in some circumstances.
And I think you're supported in that by a comment, someone saying they've done contempt proceedings in the CoP for breach of an exclusion zone around the protected parties, and the first breach was dealt with by warning, and the second he got a suspended sentence. So yeah. Validation, in case you needed it. Indy, I'm conscious that I haven't asked you any questions. Is there anything that you wanted to add in relation to those that Lee has just answered?
No, not really. Just to emphasise, as Lee said, but I think very well, when considering a application for contempt, there's various considerations that need to be made, but also that the party making it has to be prepared to enforce any breaches of the orders, as the court will clearly be interested in that factor.
Thank you.
I think that's reminded me. I think I've occasionally had, well, I've had one case I can think of where we had fact finding. We, on the basis of that, got fairly strict orders with a penal notice, and then there were breaches, and the local authority didn't really do very much in terms of bringing a contempt application. And then you've got the judge looking at you, sort of asking, well, why did we go through all this pain of doing fact finding and getting an injunction if you're not going to enforce it? So you do need to think about enforcement and the possibility of asking the court to send somebody to prison when you get your orders. So I would think about contempt early on rather than just when something's gone wrong.
No, that's a really good point. Thanks, Lee. I'm cautious at 4 o'clock, but still lots of people here. There's a couple of questions that we can still address, so I'm happy to go on if Lee and India you are.
Yeah.
We've got a very short question about inherent jurisdiction. What is a collection order, as mentioned in the last case? Essentially, it was what it says it is. So the tipstaff went to the property where P was and collected P and brought him to the appropriate placements. So what it says on the tin. The second question in relation to the inherent jurisdiction is in relation to buy-in from the individual. So the question is, on the court taking action, if the vulnerable person cannot or will not take an advantage of an opportunity to leave the situation and make an independent decision, what do you do? Is there any indication of when the court will decline to take action due to the vulnerable person's repeated refusal to engage with support to leave the dangerous situation? I think the first point here is that very, very many of these cases deal with people who are extremely vulnerable. They don't realize that they're in that situation. So they've been in the relationship for a long time, and there is a lack of insight into the dysfunctional nature of the relationship. So we have to give them the time, that safe space, in order that hopefully they can gain that insight with the help of whatever psychological therapeutic support can be put in, such that they then have the buy-in. So I think in most of the cases I've dealt with, the beginning, the individual is not necessarily willing to be separated from their father or their mother or their partner. Lee, India, is that your experience?
Yeah, they're really difficult cases, and it's relevant, the sort of degree of objection and the like, but it's not necessarily an obstacle or a complete barrier.
The question goes on to say, are there any indications of when the court will withdraw orders and support to force the vulnerable person to leave a dangerous situation if they consistently insist on returning? So that's that case where the court, excuse me, the case that I referred to, where the court eventually said the inherent jurisdiction is not unboundaried. So where the intervention no longer has any effect in providing a safe space and or in providing a facilitative tool for the individual to make their decision. When you can say you've reached the end of the line, then that is the end of the line. And in each case, it will depend on their facts.
There is there has been a debate as well, I think, Peggy, about whether under the inherent jurisdiction you can deprive somebody of their liberty to, enforce what you think is a good answer. And I think in one of the cases of one of Mr. Justice Hayden's cases, he did do that. He put somebody in a care home deprived of their liberty under the inherent jurisdiction. But Sir James Mumby, had by then retired, but gave a very interesting talk where he basically said he thought that was unlawful, and I don't think it's been done in another case since. So it's that boundary point. You can't go so far in the inherent jurisdiction. It's all about facilitation and giving space. You don't go so far to actually imprisoning somebody because you think it's in their best interest. That's not what the inherent jurisdiction is about.
Yeah, no, exactly. The point as to deprivation of liberty is a really interesting one. So the first additional point I would make is that if the person does not have a mental disorder or is not of unsound mind, then you cannot use the inherent jurisdiction at all to authorize the deprivation of liberty. So their lack of capacity under the inherent jurisdiction may have arisen because of their personal circumstances or the coercive control, so it wouldn't be a mental disorder. But yes, it's very difficult to persuade a court that you are acting, that you're trying to help someone by depriving them of their liberty where they're perfectly capacitous to decide to live with someone. So it is difficult to persuade a judge to do that. So I agree, Lee. Another question on inherent jurisdiction, it says, in respect of inherent jurisdiction applications, often the client will seek to rely on historical information. How relevant is historical information, and will it suffice to bring an application to protect a vulnerable adult? My experience is that historical information is extremely important. Sometimes you need it to show the pattern of the behavior, to show the pattern of coercive and controlling behavior that has taken place over time. So each particular incident may be a tiny one, but cumulatively, you can see that pattern. So I would say in that sense, it is relevant. India, Lee?
No, I agree. I agree.
Another question, I think, on the inherent jurisdiction. We are finding that judges at the High Court are not likely to give us protective orders for someone who has capacity. Is it your experience that judges are more inclined now to give those protective orders? From my point of view, it's difficult to say whether they are or not. It comes at a stage beforehand when I'm asked by my local authority client, can we go to the inherent jurisdiction for this particular individual, because you may have a case of an elderly lady, for example, who is hoarding, but who ostensibly has capacity within the meaning of the Mental Capacity Act, living in very, very difficult circumstances, and the local authority simply wants to do something, and the only option is an inherent jurisdiction. In those types of cases, we may be pushing the boundary as to where the inherent jurisdiction will step into, because I think originally in the SA case, they did say that the inherent jurisdiction should be used sparingly in cases. So it may be a function of more people hearing about the inherent jurisdiction and wanting to find a solution, and the judges are simply holding the line.
Yeah, and I think it depends as well a little bit on which judge you get. Some judges have different views and approaches.
And also arguably depends exactly what protective order is being sought.
Yeah, it's a difficult balancing out lots of different factors, aren't there? And so it's rather difficult to predict how each case is going to fare, which is not a great answer, but it's the reality.
I think those are all the questions that I can see. So in that, yes. So in that case, I will close this webinar with thanks to Lee in India for your brilliant talks, and thanks for everyone that gave us some questions and for attending. Thank you.
Thanks all.
Thank you.